Welcome to the Legal Strategies for Repair, Accountability, Precedent and Progress session. I'm your convener, Esther Xosei, and we have a very distinguished list of guest contributors, speakers today. I'm going to ask speakers to try and stick within the time of 7 minutes. And please, we're going to hear from all of our contributors, and then we'll have a Q&A at the end. Speakers, when you see me with this 1 minute sign, please pay attention, because I will have to cut you off if you don't. So what is this session about? This year's conference is focusing on the progress that reparations movements have made, the policy changes needed to progress the call for reparations. The session explores the multiple legal pathways available for advancing reparatory justice, from litigation and parliamentary inquiries to international human rights frameworks and community-led accountability processes. What legal strategies are currently being deployed? Which precedents strengthen the case for repair? And which are being ignored or denied? How do communities and social movements build counterpower to challenge governments that refuse to recognize existing legal rights? And what does genuine progress look like when legal frameworks themselves may need transformation? So we're going to hear from our speakers, and then we'll obviously hear from you. And so I am just going to announce all of the speakers, and then we'll work out the order. But the speakers that we have, who we're going to hear from first, are Dr. Nora Wittmann. She's an author, Pan-African legal scholar. We will then hear from Sister Mahupa Handura from the Ovaherero Traditional Authority. We will then hear from Corinne, Elle, who is from Precision Architecture and PARISC. Then we're going to hear from Jacqueline McKenzie, who's a partner at Leigh Solicitors. And we will hear from Clive Baldwin, Senior Legal Advisor at Human Rights Watch. And then we'll hear from Gretchen, who I hope that we will get a video for if she's not here in person. She's an independent reparations strategist and diasporic advisor at reform initiatives. Okay, so first of all, we're going to hear a presentation that you will have to listen to, watch on your screens, because Nora Wittmann is not able to be here in person because of the time zones, and I believe she's in the Caribbean right now. So if we can have the video, please, that you have.
Greetings and good day, UK Reparations Conference 2025. My name is Nora Wittmann. I'm an international law researcher.
Sorry, can we raise the sound?
I cannot be with you live today because I'm in a different time zone at the moment with my children, so I need to pre-record this before starting. I want to thank the organizers of the conference, most of all the MP, Bell, Ribeiro Adi, for having me and organizing this important conference, and also thanks to Esther Xosei for her great works always. So some of you might be familiar with my book and my work, in which I established the illegality of transatlantic enslavement and slavery in international law, and consecutively the right to African reparations in international law, which was adopted by the American Society of International Law and taken up by several initiatives such as CARICOM and the lawsuits against the French state being brought in Martinique, for example. For those who are not familiar, I will recap briefly some points, but this is not what I want to focus on today. What I want to focus on today and my contribution is what kind of reparations in this global African claim can be about, and what they cannot be about if we take international law as a guide. So in my previous research, what I basically did was show that the formerly hegemonic opinion that denied African reparations on the basis of saying that so-called slavery would have been so-called legal at the time. And that is important because in international law, there's only a right to reparations if the behavior or the acts in question violated the law, the international law in force. However, when we do that, we must be clear that international law was not European law. We must not look at the European laws that came on in the 18th century, whatever, that tried to declare slavery legal. That is not the international law. We need to look at the African laws, at the laws of other peoples, and then bring that together to see what the international law at the time was. So that is what I did, gathering all the sources and historic documents that I could get my hands on throughout years. And what came out is that I was able to establish clearly that the acts that were constitutive of transatlantic enslavement and slavery for all those centuries were clearly in breach, in violation of general principles of international law. Yes, even by some of the European laws, or most of them, rather, what happened was illegal. That is why some of those slave codes in France, for example, never entered into formal force. Yeah, but this is not what I want to focus on today. Today I want to bring our attention to something else, and I want to start it with a quote by the great Amos Wilson, and I will quote it as it is, though I am not African. So Amos Wilson said, "We must recognize African people that it is not about getting a piece of the stolen gains of these people, but to stop their thievery and rape of the world, period. So it is not about being left out of the mainstream, it is about bringing into being a new world order." End of quote. I find this very relevant when it comes to what we see happening around reparations today. And I want to bring this together with what the Permanent Court of Justice, the Permanent Court of Justice, which was the predecessor of the International Court of Justice, laid out as the fundamental rule of reparations in international law to this day. The Permanent Court of Justice proclaimed in the Churchill factory case that, I quote, "Reparation must, as far as possible, wipe out all the consequences of the legal act and re-establish the situation which would, in all probability, have existed if that act had not been committed." That is the most fundamental rule in international law when it comes to reparations. So, what is crucial is that we must be clear on what is the damage, and accordingly, what must the repair consist of. The times that we are speaking at are very crucial. The system that was created on the fundament of transatlantic enslavement, as laid out by Eric Williams, Walter Rodney, Kehinde Andrews, and many others, poses a very serious and real threat of extinction of humanity by humanity. But not just by any humanity, but still at the instigation and at the profit of the societies of the descendants of the original perpetrators of the crime that we are here to seek to repair. So, when in recent times we see capitalistic, neoliberal, philanthropic individuals and institutions coming onto the reparation bandwagon to declare that they are here to show that reparations would not be bad for business, I cannot really feel good about that. Because capitalism at its core and foundation has always and always will depend on the violent and brutal continuation of the crime to extract African resources at the cost of African lives. That has been a constant, the constant of capitalism. So fundamentally, if we want to move in accordance with international law, reparations cannot be about aiming to catch up within this system, within this destructive illegal system. It cannot be about development initiatives, funds and grants aimed at catching up within that system. But reparations need to be about bringing into being a new world order. Fundamental, when we look at the damage and at the fundamental rules of reparation international law that I've just mentioned, is the restoration of sovereignty over African resources to African people. None of the bigger wars that we see, even the smaller ones, nor the artificial intelligent menace, because all of these need African resources to run. The large-scale pollution, none of that could happen on those apocalyptic levels without the structures of exploitation that run since transatlantic enslavement, and through which still dozens, hundreds of billions of worth of resources are taken out of Africa every year. The biggest drivers for climate change are not car emissions or aviation emissions. The biggest drivers are war, the industrial military complex, and factories. So all of these feed the culture and mentality that was also put in place with transatlantic enslavement, starting there, that it would be desirable to consume and produce at whatever cost for those other fight, for the future generations and for the earth. This is also what reparations need to be about. So all these weapons factories and so on run to a substantial part on African resources, rare earths, minerals, oils. What I also need to mention in this context is that given that all these resources are still taken out violently, brutally, and destroy African communities, African lives on the continent, which makes that African people are risking their lives to trying to cross the Mediterranean, to follow the loot and reach into Europe. When we calculate the numbers of those Africans that are documented to have perished in the recent years trying to cross the Mediterranean, and those documented, most are not documented, but those documented that are captured by, for example, Tunisian state forces paid, funded by the European Union, to be brought into the Sahara Desert to die there, just so that they cannot reach Europe and follow the loot that Europeans took. If we calculate those numbers over a time span of 400 years, so somewhat comparable to the time that transatlantic slavery went on, we reach a number of 4 million people perished. So I don't think that it's possible to say that we are dealing with a crime that is not still continuing. So given that in international law, reparations need to come according to the damage, all of this needs to be taken into account. I don't think that these state agencies that are responsible, that this amount of African people perish, are people that reparations can be negotiated with. I do not think so. So since it is according to the nature and extent of the damage that reparations are determined in international law, and so many people were ripped out of Africa, so many people were and still are destroyed on the continent of Africa to build and keep up this world system that is currently predicted to extinguish humanity, And given that the perpetrator descendants and the present-day contestants for dominance in this world order, like China, like Russia, continue to have access and violently take access to African resources, while the descendants of both those taken from Africa to be worked to death and the descendants of those who were subjected to genocide on the African continent to get resources, in their vast majority, the descendants have no benefit from their own African resources up to today. So beyond vast compensation that is due for the stolen labor, genocide and theft of resources, this is the damage that reparations need to address if we move in accordance with international law. And primordially so, because the cessation of the illegal behavior is the first step of reparations in international law. So reparations must be bad for capitalistic business if we want to follow international law. So in closing, I want to mention that I have a book that will come out very soon, within the next few weeks, hopefully published by Seaborn Publishers, that will go into the depth of all of these issues, and it will be entitled Capitalism and Reparations. So thank you very much and have a great conference.
Okay, we just heard from Dr. Nora Wittmann. We're going to move swiftly on, asking those of us in the room, especially our speakers here, to also think about, when you're making your contributions, any policy changes that you feel are needed to make justice a reality. And of course, hopefully we'll be able to hear from some of you in the audience too. We're now going to move swiftly on to Mahupa Handura from the Ovaherero Traditional Authority.
Okay, good day. Today I just want to introduce the Ovaherero struggle with the Namibian government and the German government. As you all know about the history of Ovaherero people, we are a small community of the Nama and Ovaherero, close to less than 6% of the whole community in Namibia. So the struggle that we are having, it's exclusion of us sitting at the table with the German, to speak to the German government, to ask reparation. And that is done deliberately by our own government, the Namibian government. So we took our case first to the US court. And when we took our case to the US court, it was thrown out because of, on the ground of lack of jurisdiction. Sorry that I'm not in law. I'm just trying to bring my people case here. Yeah. So I will make a lot of mistakes. But we are not sorry that we took the case there. At least it generated the international awareness. So after that, now where we are, we have a case in the Namibian government. Thank you. In the Namibian government, where our own government again, it's trying to shield the German government by not coming to the Namibian court to represent themselves. The Namibian government we were having, on the 7th of October, we had a case where the Namibian government used the lawyer paid by the taxpayers' money to represent Germany to try to tell our people that then the German government can't come to a Namibian court because Germany has immunity. But the case that we are talking about, it's a genocide case, and it happened in Namibia. Still, the German government is still benefiting from our land because the land that we lost, the cattle, the animals, the properties that we lost are still in the hands of the Germans that are living in Namibia. So, we are sitting with a big problem because we are fighting a German government and again our own government. So that the Namibian government, what it's doing, it's trying to twist all the laws so that the Namibian laws can be against us. But we are not going to be silent by anything. Until justice is done, we will fight both of the government. I'm here in asylum. My case is being denied deliberately. The harm that is happening, it's being seen everywhere. When you Google what is happening in Namibia with our people, the evidence is there. I rest my case.
Thank you.
Thank you for sticking well within your time. I've been told we have to wrap up by 2:10, so I would ask other speakers to be also just as disciplined. Thank you. We're next going to hear from Corinne, Elle. That's okay.
Good afternoon, everyone. My name is Corinne, Elle. I'm a solicitor registered in England and Wales. I'm also a member of the PARISC, the Presidium of PARISC, Kofi Maweli-Klu, that a lot of you know. I'm also now the General Secretary of a movement called Lilipac, the Lioness and the Lions for the Pan-African liberation of Cameroon this year. I will try not to speak without my notes because tomorrow we're going to still be here. When it comes to defend our people, I can talk all night through. When we talk about legal strategy for repair, what we're really asking is how do we turn the demand for repatriation justice into lasting lawful change? There isn't just one pathway. There are many interconnected routes that all move towards the same goal: accountability and repair. Some strategies use formal, like litigation in national and international courts, parliamentary inquiries, human rights frameworks to demand acknowledgement and redress. These are important because they set legal precedents, and you know we lawyers, we like legal precedents. They build a public record that say these harms happen and they matter. But law doesn't only live in courtrooms. As we know, across Africa and the diaspora, we also see community-led accountability processes, truth commissions, people's tribunals, reparation councils, and local justice circles. These create spaces where communities define what justice means for them, not just in legal terms, but in moral and cultural ones too. Together, these strategies remind us that repatriation justice is both legal and political. Legal and political. Courts can't confirm rights, but movements must make those rights real. So please remain activists like I am. We need movements. Progress comes when legal action and popular mobilization work side by side, when lawyers, scholars, activists collaborate to translate pain, the pain that we've been through, into policy and history into law. So this session today isn't just technical tools, it's about vision and courage. To stand here, we need vision and courage. How can we use law creatively, collectively, and pan-Africanly, like Esther is saying, to move from accountability to precedent to true progress, where repair becomes part of how justice itself is defined? You all know that when we talk about reparation, we just can't think about money or compensation. We have to think about justice, about repair, about restoring the right of African people to define our own future. Because true reparation means African self-determination, especially in law. It means asking who gets to decide what justice looks like. For too long, our systems have been shaped by colonial powers and global institutions that don't always act in African interest. So when we talk about reparation, we are also talking about how we remake African law for African people. Look what's happening now. Countries like the Alliance of Sahel States, like Mali, Niger, Burkina Faso, have withdrawn from International Criminal Court. Rightly so. It's a bold statement, I know, but what they are saying, what the AS are saying, I was in Burkina Faso 2 weeks ago. I didn't have the pleasure to meet Traoré, but the leader of my movement met Traoré. And we tried to move forward through this justice for African. What the AS are saying, we want justice in African terms. They want to build legal frameworks that reflect African priorities, not outside control. At the same time, I'm from Cameroon, my country is Cameroon. Look what France's role in Cameroon is doing now. They just gave a report to our president about the crime the Cameroonians went through. The war was so brutal that Cameroonians now are all scared to even stand up against colonialism. That shows exactly why African communities must come together and speak with one voice. Because if we don't define justice for ourselves, someone else will define this for us. I will try to stick on my time. 2 more minutes. Okay, I can go on. So I believe this cannot be done country by country. It has to be pan-African. Each time I can see any movement from us, from Afro-descendant, from anywhere, I stand by you, and I want to fight for justice. Communities across borders collaborating, sharing solutions, and creating lawful, collective ways to hold power accountable. So when I talk about reparation, I'm talking about more than redress. I'm talking about rebuilding Africa's justice system for African self-determination. Because true repair is not given to us, it's something we create together. In my movement as the General Secretary of the Lily Pack, we are trying to let Paul Biya go because he has served the imperialists and the France for too long. And we need support. We do need support. We cannot do without this in isolation. So the work of liberation and reparation is not only about words or idea, it's also about building political power. If we have more political people like me in power in Africa tomorrow, we will be strong because we can then voice at the highest level. That's why we need, and I came to you today to say that we need your support for our movement, from communities, from youth, from leaders, from the diaspora. When people unite around a shared vision of justice, our voices become strong enough to shift institutions and to challenge the global system and systems that have kept Africa dependent for too long. So I'm going to conclude now. When we talk about reparation, we talk about remaking African law. We must also talk about Pan-African political power, because without power, justice remains a dream. But with unity, courage, and the support of our people, that dream becomes a movement that, like the AES, chooses African freedom first. Thank you.
Thank you. Right to time. Now moving swiftly on to Jacqueline McKenzie.
Thank you. Good afternoon, everybody. I've got quite a long paper, so it might sound a bit disjointed because I'm going to be jumping all over the place, just to make a couple points, given that we've only got 7 minutes or so. So firstly, I'll start off by saying there is no question in morality and ethics that reparatory justice should be paid for the lives lost, the brutality of the transatlantic system of the enslavement of Africans. We know that supernormal profits were made from this trade, for lack of a better word, with those profits continuing well into the era of colonialism and even today. We're all familiar with the revelation about the treasuries, we won't go into that, and we've seen attempts to try to quantify, or what lawyers call place quantum, with figures 77 trillion mentioned by the Brattle Group, providing a lower bound estimate reflecting conservative assumptions, such as the interest rate to compensate for the time value of money when we bring the value of stolen labor forward to today. And then there's been lots of other studies, and some much higher and some much lower. The enslavement of Africans was a crime against humanity. The Charter of the Nuremberg Tribunal defined crimes against humanity as murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population, whether or not, and this is important, in violation of the domestic law of the country where perpetrated, because we always hear Britain, this thing about whether it was legal or not. In 1948, the United Nations promoted the Convention on the Prevention and Punishment of the Crime of Genocide, which the Rastafari have long cited. Genocide includes deliberately inflicting on a racial or ethnic group conditions of life calculated to bring about its physical destruction in whole or in part. And we're seeing now this issue about what is genocide being played out on the international stage. The convention gave new legal form to an old concept in international law. We are living testimony and the evidence to show that the enslavement of Africans and the extermination of the language and culture of the transported peoples constituted a continuing crime against humanity. International law recognizes that those who commit crimes against humanity must make reparation. This was defined by the Permanent Court of International Justice as long ago as 1928. There are numerous examples of reparations being paid to almost everybody except African people, except for the case of the Mau Mau, which my firm Leigh brought in the UK courts, and of course of which there are challenges. States have pursued claims on behalf of injured nationals, their injured nationals, against other states that have violated international law. And until recently, no African state has actually done this, although we now see the Jamaican government saying that they're bringing forward a petition, and I'm going to skip all of that. It was meant to have been issued in the UK on Emancipation Day, but that didn't happen. I'm not quite sure what went wrong there or whether they're still working on it. And we, as lawyers, have to be very careful about bringing these cases because we know there's inequity in justice. And we know judges don't necessarily like opening up what they call the floodgates to policy. And we are starting, Black people are starting in a negative space when you go anywhere near a courtroom, no matter how good your lawyers are. And we heard earlier on that only 1% of the bench is non-white in the UK, and most of these cases are coming here. But we've also seen some terrible setbacks. I mean, our sister here, who eloquently talked about the Herero people. I mean, we've seen what happened with the Tulsa case at the Supreme Court of Ohio just 2 years ago. And there are victims of that massacre still alive, let alone when we're talking about evoking something that happened, hundreds of years ago. We also saw in 2023 failure of the reparationists in Guadeloupe at the Court of Cassation in France. So we have some mega problems. Do I have another 2 minutes? Is it 2 minutes? Right, okay. I just wanted to see what to leave out. But we have seen the Security Council passed a resolution binding in international law requiring Iraq to pay reparations for its invasion of Kuwait. In 1988, the United States government passed the Civil Liberties Act in order to make restitution to Japanese Americans. And sorry, I'm just going down so I can leave out. I was going to tell you about Namari in New Zealand. I'm going to leave that out. We all know about how much Israel has received for the Holocaust and Jews living in other countries. And we know in 1995, the late Queen Elizabeth personally presided over the signing of the Waikato-Rapatu claim settlement, giving reparation for the seizure of Maori land. So we've seen so many examples, and there really is no legal barrier. In my last minute, I'm going to move out who the defendants are. I wanted to talk about Drax, because I think Drax is particularly interesting, given that this family are still benefiting. And what was very interesting to me is that I've asked the Barbadian government, where is their receipts for acquiring the land? And, how did they acquire it? Why can't the government just confiscate it? There's no evidence of them owning it. And somebody said to me, well, they must, the land was just abandoned and people took it. But there were houses. We now know there were houses on that land. So this is absolutely ridiculous. But my final half a minute, I want to pay tribute to you, Leigh Burnham, from Doughty Street Chambers, a barrister sat there, because I'm actually just going to talk for the last few minutes, or seconds rather, sorry, don't want to frighten Esther, about... So I'm just scrolling down to the last bit where I have some notes that are inspired by you, Leigh, and it's about what we might do. And I would have loved to have gone into them, but we can't. But I'll just give you the headings. Contentious proceedings before the International Court of Justice. And you, Leigh, does helpfully tell us what some of the pitfalls are, but also how we might do that. And we hope to be working with her very closely on looking at some of that. If we can work out some of the issues that Esther raised brilliantly in her about who and how, and how do we do this? Also seeking an advisory opinion on the question of state responsibility. Is another thing that Leigh's been talking about. Proceedings against the United Kingdom under Section 4 of the 1833 Judicial Committee Act, and a very interesting point about whether those countries that are still under the Privy Council themselves can bring some claims. But there's quite a lot there. It's really, there's some potential. There is some potential to bring legal claims, but we just have to be careful. Thank you.
Thank you so much, Jacqueline McKenzie. And I don't believe we have Gretchen here, so our last speaker is Clive Baldwin, Senior Legal Advisor at Human Rights Watch. Thank you, Clive. Over to you.
Yeah. Thank you, and good afternoon to everyone. It's always an honour just to attend this extraordinary conference each year. It's even more of an honour to be on the panel with these panellists. Just going to raise a handful of issues in the time available. One, so much has been said about what reparations mean in law and morality. I just wanted to add that it's a very basic, fundamental principle of any system of morality, any system of law I know, that when harm is done to someone or something or some people, the person, the institution, the state that did that owes repair, owes an obligation to make that right, whatever form making that right does. I think every legal system accepts that. Even European governments accept it at the biggest level when talking about states like Russia owing reparations in Ukraine for harms and crimes they've done. But European states don't accept it when it comes to Africans and the history of their colonial atrocities. And they still are fighting this even at the United Nations and elsewhere. But as has been said, the tide is turning globally because they are in a minority. And just along all the things that have been said, I want to stress one part of that. It's a legal principle as well, that nothing should be decided on reparations without the people affected, without the communities affected, not by states over the top. But this is what we hear again and again. I wanted to just mention today another African community struggling for reparations because they're in Parliament next week, the Chagossian community from the Indian Ocean. I see friends from the struggle in the audience today. Very briefly, to know the Chagossians, they are an African people, also whose ancestors were also kidnapped, enslaved, transported to the Chagos Islands of the Indian Ocean, where they are still Britain's last colony, formal colony in Africa. But then 50 years ago or more, the entire people population was forcibly deported from their homeland by the UK with the United States in order to make way for a US military base on Diego Garcia, a crime which has been exposed by the Chagossian community themselves, bringing legal cases. But it's a crime against humanity, of forced displacement, of persecution on the grounds of race, because the racism is blatant, it's written down in the documents they exposed, and a crime of prevention of return today. Because of litigation, including the International Court of Justice, the community there's a new treaty between the United Kingdom and Mauritian governments about the return of the islands, the territory, not the main island, Diego Garcia. But it even in the beginning acknowledges that the UK recognizes the wrongs of the past because they cannot deny what happened to the Chagossians. But this is now symptomatic, and that's why I think the Chagos people are important for any struggle on reparations, to see even when confronted with overwhelming evidence of what happened, the UK government, like other European governments, will just say, it's all in the past. Forget about it. Yeah, that was wrong, but not now. Even today, they're still denying the Chagossian people the right of return to their homeland. And that's in the treaty. But to say it's going into the UK Parliament now, a bill about this treaty, it will be discussed in the House of Commons on Monday, and then going to the House of Lords. So one actual, is a recommendation, say, if anyone's interested, ask your MPs and other people involved right now to say, what are you doing? What are you saying about the Chagossian people, not just the land, about their right of return and right of reparations for a crime which is ongoing? And I just also wanted to mention briefly in terms of legal strategy, what Jacqueline mentioned this morning, and others have mentioned the International Court of Justice, this UN court, a court of states, but one which has played this role on reparations. Also, because the Chagos issue is an International Court of Justice opinion, that's what's forced the United Kingdom to make a treaty, but without the Chagossians themselves. But it was because when that case came to the ICJ 6 years ago, they heard from Chagossians directly. They made an anti-colonial ruling, but they did not address reparations. Certain judges, the Judge Patrick Robinson, who many of you will know, as a campaigner, he said they should have done in his separate opinion, but they did not. And therefore, today, the United Kingdom could say, we're complying with international law. We're complying with the International Court of Justice by not giving reparations. But the movement is different. Then there was another ruling, another advisory opinion by the ICJ last year about Israel and Palestine, the occupied Palestinian territory. In that ruling, the ICJ has done a few paragraphs, just setting out very clearly why Israel owes reparations to Palestinians, who it has committed, it just says unlawful acts against, including displacement, and also stressing their right of return. And that's a new step, I think, for the ICJ. So that's why the work that Jacqueline is doing, which is so important in thinking about how to get another advisory opinion. And I think that's why finding a way with courts like the ICJ, which is made of states, and it's a state-led institution, but finding ways for peoples to be part of it and address these issues of reparations. And I think the other advisory opinion on climate change, which was started by activists and groups, but through states, is key. But we'll still be needing to find those state allies. So therefore, having the African Union, CARICOM, and other states will be important. So that's where I finished with other suggestions. And the one final suggestion I'll make on international law is that use all the states, use all the legal proceedings around the world, and knowing in human rights terms there are two powerful courts and systems in the world which are not European and not European dominated. The Inter-American system of human rights, which address issues like indigenous people's rights and other issues which many Caribbean states are part of, and the African system of human rights, which I think is the most powerful in the world and is about human and people's rights, which is therefore it's very powerful. So go back to that. So thank you.
Thank you. And my apologies, we actually do have Gretchen with us, Gretchen Rohr, I believe. If I've got it wrong, Gretchen, please correct me. Independent Reparations Strategist and Diasporic Advisor, Reform Initiatives. Over to you, Gretchen, who is online.
Are you all able to hear me?
Yes, yes.
Wonderful, wonderful. Thank you so much, Esther. I've had to speak after you. on a panel, and it's always been one of the most difficult things. I'm telling you, even after this panel being after this morning's opening by you, you just really get us started and really pull into action. So thank you for all your work, and thanks to the All-Party Parliamentary Group for continuing to create this space. As stated, I'm Gretchen. I'm a senior advisor with the Reparations and Reparations Strategist with Reform Initiatives, which is a Pan-African cross-continental think and action tank based in Accra, Ghana. And I'm also a proud member of Movement for Black Lives, which is an ecosystem of over 180 organizations across the US, which advance a shared vision and policy agenda to win the rights, resources, and freedom of Black people. I co-lead our reparations work group, and we are right now building out our vision, a new 10-year vision for Black lives, for reparations. When we met last year, we were charged with in this panel to speak about, how we can shift from acknowledgement to action. And I think at this time, there has been quite a lot has taken shape, not just aspirationally, but architecture that we have built. And so really excited to hear about all the progress that has been secured by our partners around the globe. And I thought I would just point to just a few milestones and steps that I've seen directly with my work, but also more broadly out there. So just broadly, I would say that the key evidence for me that there has been significant progress is that when APPG was launched 3 years ago of these convenings, I was still at Open Society Foundations, and I was aggressively chasing down other litigators. Some of you all know I was chasing down while we were preparing petitions for the Haitian civil society organizations and for restitution, and also, providing guidance and expert in international human rights strategy for the attorneys representing the Ovaherero and the Nama in their pursuit of reparations, as you heard about earlier. And at that time, we could not find probably more than 10 active cases, which included those that were pre-filing on colonial reparations. And the docket today has multiplied to the point where I don't even know if those of us together in the room do know of all of them, which further underscores the importance for us to be speaking, to speak with each other, to coordinate, and to ensure that our strategies are aligned and embedded with the community objectives. But what I see in just the last few years is that our strategies are sharper and our coalitions are broader because they have been clearly articulated by survivors that this is not just about what past has been done, but what justice must deliver and how we need to change our way of lawyering. The successes I've seen is that the African Union has expanded the year of reparations to a full decade. As we spoke of, ICJ issued some fantastic findings on climate reparations, and we are awaiting any moment now. The UN Committee on Elimination of Racial Discrimination is providing, after an expansive consultation, more clarity on the scope and content of the right to reparations within international human rights law. There's also significant celebrations, and I don't think they can be lost, of how grassroots movements have been able to continue to move forward, even faced with serious retrenchment of resource support and neoliberal abandonment. Movement for Black Lives itself is celebrating its 10-year anniversary. The Ovaherero and the Nama have been moving past for decades, very much under-resourced. And the Brazilian Black Women's March is going to be honoring its 10-year anniversary in pursuing reparations. Where I sit with reform initiatives, we are linking research, policy, legal advocacy, and cultural imagination. We're trying to co-design survivor-led systems of repair across Africa, the Caribbean, and the Americas. And our work together forges some critical partnerships where we try to deliver roadmaps and help translate commitments so that these are translated into living systems that will redistribute power, land, and resources. We also provide technical assistance to major regional and government institutions, so including the African Union and its Court Commission and Citizens Directorate, as well as UN Human Rights and Gender Mechanisms. We also recognize the progress of socializing reparations is not, the progress of reparations is not simply through the courtroom, but in socializing it and redefining justice. We are going to have a festival, Reparations Festival, the Wakati Wetu Reparations Festival in Nairobi next week. It means our time in Swahili. It's co-organized with the African Futures Lab, Baraza Media Lab, Trust Africa, and Deep South Solidarity Fund. And it's not just another conference. We really need to break out of these, no critique of this one. I actually love this conference and convening. We also need to find these spaces for young people and for artists to be able to communicate and express what is the critical need to advance and change the narrative. So it's going to be a people's forum. We have artists, elders, lawyers, culture leaders, and those who will showcase different models and memorials, and it will really be a rehearsal for the future we intend to make real. Also excited to announce next month, or actually later this month, no, next month, working with Clive's organization, Human Rights Watch, and other partners to launch the Reparations Hub. This is a global collaborations where and it will be launched in Berlin by support with Decolonize Berlin. And the hub is going to be an online community space where we'll connect affected communities, civil society, academia, lawyers, and many others. It's where you'll be able to access resources on international legal and political frameworks, as well as UN reports and some analysis. We've spent a significant amount of time doing this year is supporting behind the scenes and in critical strategic and litigation surgeries, how to carve out clear remedies, prayers for relief, and litigation strategies that are not going to append or destroy actually the efforts that have been pursued by others or are in alignment with others, whether it is in domestic courts in South Africa and Namibia, or whether it is in the regional seeking advisory opinions from regional courts and commissions. That work, and much of it is presented through materials that are still available at the Pan-African Lawyers Union. We've worked with the African Judges and Jurists Forum on advising regional litigators in Southern Africa as to how to pursue claims in domestic courts, and also working to really change the form of lawyering in partnership with the Center for Applied Legal Studies in South Africa, so that lawyers that are embedded within movements can be driven. And much of that work is on climate reparations that they are doing there. So it's been just a pleasure to be able to learn and be able to advise and be able to contribute to these cases without filing them all. And as was said earlier, there is a lot of exciting cases that are going to be filed in within the next year. We'll be talking we'll be having a different conversation next year. Finally, not sure how many minutes I have left, or a minute.
That's it, about half a minute.
Half a minute. Okay, well, wanting to speak about, most of my time is actually doing technical assistance, providing technical assistance to the African Union. And yeah, we help define the roadmap for justice through reparations. And just want to really make a call out for all of us that are of the diaspora. The diaspora is the 6th region of the African Union. And that has not necessarily led to a clarity as to how we can engage, what our role will be. But there's much that is being requested of civil society, the Citizens and Diaspora Organizations Director, as well as Economic, Social, and Cultural Council, have been convening a number of consultations with the diaspora and with civil society as to how we can have some form of contribution to the decision-making, to the construction of institutional seats. And so I encourage you, particularly as we have parliamentary members here, to consider what role those who are elected Black leaders in countries that are not Black-led can play in representation within the African Union. There are a lot of amazing ideas there. And then finally, I just want to put a pitch for all Black women, actually all people who support Black women, to join us November 25th in Brazil for the Million Black Women's March. The Adara Institute and Mario Franco Institute, you can get information on their websites, as well as there will be more postings by Reform Initiatives. Thank you so much. I really do feel that we have gotten to the point where we've proven that there is more that can be done than we can even expect in a year. But I hope that we will be able to do it together and in alignment.
Thank you. Thank you to Gretchen. And technically we're out of time, but I'm going to see if I can take 3 questions. Let's see how much we can get. If we can, yep, 1, 2, 3. I'll hear those 3 in order, and then we'll ask for responses. Yes. Do you want to come to the front? Are you able to, if you can, so we can hear you and see you? Okay, there you go. I hope it's on. Yeah.
Hello, my name is Munir Malik, born in Africa, Kenya, Nairobi. So quite connected up with what Jackie had to say about Mau Mau. I was a young toddler when that was taking place, so quite interested to see how that develops. But I visited it again after about 58 years, 2 years ago, and noticed that there is not as much progress as there should have been. And it made me think about other places too. Been involved in anti-apartheid movement for a long time and know about the difficulties in South Africa, Namibia, and all of the liberation struggles that took place in the frontline states. It appears to me, alongside the reparation legal procedures that we're following, that there should be a parallel track on how the formerly exploited world can liberate itself economically. And it makes me think that there should be, there was mention of African Union, there should be a little wider than that. And Trump and his tariffs have indicated the world has got to exist without European intervention in our economic strengths. And I wondered if there was a view that speakers have on how that can be achieved.
Okay, thank you. Second person? No, it was, who was it? It was him. Yes, the first 3. There you go. Yes. And then it was the person in the middle. Thank you. And that's all we got time for. Please be brief. We only have like 1 minute.
Okay. Hi, everybody. My name is Roger John. I'm a Pan-Africanist, always very interested in reparations. In fact, believe it's absolutely essential. My question is, with a little preamble, hasn't the time come? It's always about money for a capitalist world, for a capitalist system. It's always about money, money's worth, or value. Are we undermining ourselves to constantly have this line where we deflect as soon as the money is that we are actually owed? As soon as that's mentioned, we're deflecting to say it's not just about money. In this kind of a system, the inability to pay your debts is shameful. And if the state, if the various states that have been involved in our oppression are kind of shrouded in that shame, and we actually stand on that, then surely it has the effect of giving us strength and power in that we have, no matter where we are, a set of people who cannot pay us, can never pay us what they owe us. Why then should we continue to do this deflection? It's not just about the money. Okay. Surely it's about both.
Okay, thank you. And sorry, it was this person in the middle. I have to take 3 questions. Yeah, go ahead. Yes, thank you.
My name is Esther. I'm a parliamentary candidate, former parliamentary candidate, local council, etc., etc. So it's a simple question. I'd like to thank the panel for the fantastic work you guys are doing, but particularly for this lady sitting over there, You said you're asking for Pan-Africans and local community to help you to achieve the objective. Can I ask you, how can we, as a community and local community, can help you achieve that objective?
Thank you. I'm going to ask for brief responses from our panel first. Thank you. Anybody wants to respond to those three questions? The first point that was raised here around the, what's happening around the economics as well, that it's a legal and economic struggle combined.
I'm quite happy, because we haven't got much time, just to take one, and Munir's one. I think it's really problematic, and it does actually beg the question, and it kind of touches on the not just money thing, that we have really bad governments in Africa and the Caribbean and all over the world. I mean, we're starting here. Actually, I don't know why I've managed to reach the Caribbean and Africa and forget this one here. But so what exactly is going to happen? Because if we're handing them money, what's going to happen to it? I mean, that's an issue. But in terms of, it's not just money, because we've got debts and we can't pay our debts. Well, it's going to be lots of different things, isn't it? It's about education, it's about psychology, it's about social justice, racial justice, as was mentioned earlier, and debt forgiveness, development infrastructure. It's a whole load of things. And despite what we might think about CARICOM and its 10-point plan, it is a starting point to start look at some headings. As lawyers, we look at what's called heads of claim. And there will be many heads of claim, but absolutely money is going to be one of those. But money is always a problem, really, because if the wrong people get it, we're going to be no further forward.
Thank you. Any responses to the other 2 points? I mean, the point around, are we not kind of undermining ourselves with not emphasizing the money, and then also what can be done to support what people can do locally or globally to support what's happening, say, for instance, in the work you're doing or anywhere else. Any of the other struggles that we've heard about, Chagossians, Ovaherero, Nama, in the Caribbean, wherever we're organising. Yeah, you want to respond?
I would like you to respond because I'm going to respond next.
No, it's for you to respond.
I would like to respond to both questions.
It's the panel. You can respond. It's fine.
To both questions.
It's for you all to respond.
Well, there's no single battle which is not worth it. Whether for money, for pain, for racism, for any single cause or legal cause you can get for our people. So I can only respond to that question by saying the money is not undermining us. And I know I might be a little bit rude, but unfortunately, this side of the world doesn't know anything about, they have two languages, money and war. So when you touch 20 pounds, everybody's on the street, they ride, there's rise everywhere and so on. So unfortunately, we talk about money because it's the only language that they know. Whatever money they give to us will never, ever, ever, they can't repair us, they will never. But we should carry on asking because that calms them down. Otherwise, the next step will be the war. I think they're ready to, imperialism is to create war everywhere to get it whether you like it or not. So every single battle, the main, for me, important point is to stop to abuse. They're gonna stop all form of abuse when we're gonna raise, talk, ask for money, ask for reparation, any form of reparation. So we're not undermining ourselves, we're touching what they know. When we talk about money, you have newspaper everywhere, anywhere else while you can carry on talking. No, it's important to ask for absolutely everything because it's their own language. Capitalism is an issue, which is not an issue for African, but it's an issue for the rest of the world. Now come to my movement. The Lily Pack is a political movement. My leader is Professor Franklin Yamsi. As we speak, he's in Russia. He has been invited by Russia today. And he wrote an important book that I recommend people to read about imperialism. He wrote a book about terrorism, how imperialists became terrorists. And he used every single thing that Donald Trump himself and his government has disclosed to the world, which is not public, which is in the domain public domain anymore now for everybody to look at. After the scandal with WikiLeaks and also Assange. So we know that they intentionally made war against us. So it's important to read that book and how you can help us. I always say that everywhere, and that's why I'm also a Pan-Africanist and a militantist and a lawyer and everything I can be, Because when you touch one person, you touch 10. And when you touch 10, you touch 11. And thank you for all of you to be here today, because by talking to you, I just spoke with 1,000 of people. So we help each other locally by you coming to here and speaking to your local community and school and everything else. I mean, Jeremy Corbyn was really clear about that on education when he touches today. Okay. So thank you very much.
Thank you, sister.
Thank you.
Okay, do you have a final point? Final point, thank you.
Just one quick point on the economic order that you met some of us know about the new international economic order that was brought up in the 1970s, especially the UN. I think Jamaica was one of the states leading it at the time. But in human rights terms, what came out of that was not just the idea of a right to food as we know it today, but the right to development. Now that those human rights that European states, most of them don't like, but the right to development is also back. It's, there's a treaty which is being thought of, it's now under discussion in New York at the United Nations, but also the African Commission on Human and People's Rights is looking at expanding its understanding in a general comment. It's the only part of the world where the right to development's in law and the international treaty and the African commissions and court have made rulings on it. So that engagement in the right to development is not the same as reparations, but they're so closely linked and overlapped, and having the reparations part of the right to development is going to be very important in the next few years.
Okay, Mr. Mahupa, thank you. Brief final point.
Okay, my request to the community everywhere internationally, the Ovaherero and Nama people of Namibia need all your support, because what we are fighting, it's two big governments. When you are fighting your own government, you don't have anything, because they make sure that they take everything away from you. So please support Ovaherero and Nama in their case.
Thank you. I'm sorry that we haven't had more time. Clearly, this is a panel discussion that needs more time because we've not heard from enough of you, but we're now eating into your lunch break, and I'd like us to break so that you can try and get some lunch before we resume again. Thank you to all of our guest speakers today, and to yourselves for being here.